United States v. Salerno, Supreme Court, 1987. Chief Justice Rehnquist delivered the opinion of the court. The Bail Reform Act of 1984 allows a federal court to detain an arrestee pending trial if the government demonstrates by clear and convincing evidence after an adversary hearing that no release conditions will reasonably assure the safety of any other person and the community. The United States Court of Appeals for the Second Circuit struck down this provision of the Act as facially unconstitutional because, in that court's words, this type of pretrial detention violates substantive due process. We granted certiorari because of a conflict among the courts. We hold that, as against the facial attack mounted by these respondents, the Act fully comports with the constitutional requirements. We therefore reverse. Responding to the alarming problem of crimes committed by persons on release, Congress formulated the Bail Reform Act of 1984 as the solution to a bail crisis in federal courts. The Act represents the national legislature's considered response to numerous perceived deficiencies in the federal bail process. By providing for sweeping changes in both the way federal courts consider bail applications and the circumstances under which bail is granted, Congress hoped to give the courts adequate authority to make release decisions that give appropriate recognition to the danger a person may pose to others if released. To this end, Section 3141A of the Act requires a judicial officer to determine whether an arrestee should be detained. Section 3142E provides that, if after a hearing pursuant to the provisions of subsection F, the judicial officer finds that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, he shall order the detention of the person prior to trial. Section 3142F provides the arrestee with a number of procedural safeguards. He may request the presence of counsel at the detention hearing. He may testify and present witnesses in his behalf, as well as proffer evidence, and he may cross-examine other witnesses appearing at the hearing. If the judicial officer finds that no conditions of pretrial release can reasonably assure the safety of other persons and the community, he must state his findings of fact in writing. Section 3142I, and support his conclusions with clear and convincing evidence. Section 3142F. The judicial officer is not given unbridled discretion to make the detention determination. Congress has specified the considerations relevant to that decision. These factors include the nature and seriousness of the charges, the substantiality of the government's evidence against the arrestee's background and characteristics, and the nature and seriousness of the danger posed by the suspect's release. Should a judicial officer order detention, the detainee is entitled to expedited appellate review of the detention order. Respondents Anthony Salerno and Vincent Caffaro were arrested on March 21, 1986, after being charged in a 29-count indictment alleging various Racketeer-Influenced and Corrupt Organizations Act violations, mail and wire fraud offenses, extortion, and various criminal gambling violations. The RICO counts allege 35 acts of racketeering activity, including fraud, extortion, gambling, and conspiracy to commit murder. At respondents' arraignment, the government moved to have Salerno and Caffaro detained pursuant to Section 3142E on the grounds that no condition of release would assure the safety of the community or any person. The district court held a hearing at which the government made a detailed proffer of evidence. The government's case showed that Salerno was the boss of the Genovese crime family of La Cosa Nostra, and that Caffaro was a captain of the Genovese family. According to the government proffer, based in large part on conversations intercepted by a court-ordered wiretap, the two respondents had participated in wide-ranging conspiracies to aid their illegitimate enterprises through violent means. The government also offered the testimony of two of its trial witnesses, who would assert that Salerno personally participated in two murder conspiracies. Salerno opposed the motion for detention, challenging the credibility of the government's witnesses. He offered the testimony of several character witnesses, as well as a letter from his doctor stating that he was suffering from a serious medical condition. Caffaro presented no evidence at the hearing, but instead characterized the wiretap conversations as merely tough talk. The district court granted the government's detention motion, concluding that the government had established by clear and convincing evidence that no condition or combination of conditions of release would ensure the safety of the community or any person. The activities of criminal organizations, such as the Genovese family, do not cease with the arrest of its principals and their release on even the most stringent of bail conditions. The illegal businesses, in places for many years, require constant attention and protection, or they will fail. Under these circumstances, this court recognizes a strong incentive on the part of its leadership to continue business as usual. When business as usual involves threats, beatings, and murder, the present danger such people pose in the community is self-evident. Respondents appealed, contending that to the extent of the Bail Reform Act, Respondents appealed, contending that to the extent that the Bail Reform Act permits pre-trial detention on the ground that the arrestee is likely to commit future crimes, it is unconstitutional on its face. Over a dissent, the United States Court of Appeals for the Second Circuit agreed. The court concluded that the government could not, consistent with due process, detain persons who had not been accused of any crime merely because they were thought to be a present danger to the community. It reasoned that our criminal law system holds persons accountable for past actions, not anticipated future actions. Although a court could detain an arrestee who threatened to flee before trial, such detention would be permissible because it would serve the basic objective of the criminal justice system, bringing the accused to trial. Respondents present two grounds for invalidating the Bail Reform Act's provisions permitting pretrial detention on the basis of future dangerousness. First, they rely upon the Due Process Clause of the Fifth Amendment. Second, they contend that the Act contravenes the Eighth Amendment's prescription against excessive bail. We treat those contentions in turn. A. The Due Process Clause of the Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. This court has held that the Due Process Clause protects individuals against two types of government action. So-called substantive due process prevents the government from engaging in conduct that shocks the conscience. When government depriving a person of life, liberty, or property survives substantive due process scrutiny, it must still be implemented in a fair manner. This requirement has traditionally been referred to as procedural due process. Respondents first argue that the Act violates substantive due process because the pretrial detention it authorizes constitutes impermissible punishment before trial. The government, however, has never argued that pretrial detention could be upheld if it were punishment. The Court of Appeals assumed that pretrial detention under the Bail Reform Act is regulatory, not penal, and we agree that it is. As an initial matter, the mere fact that a person is detained does not inexorably lead to the conclusion that the government has imposed a punishment. To determine whether a restriction on the liberty constitutes impermissible punishment or permissible regulation, we first look to legislative intent. Unless Congress expressly intended to impose punitive restrictions, the punitive or regulatory distinction turns on whether an alternative purpose to which the restriction may rationally be connected is assignable for it, and whether it appears excessive in relation to the alternative purpose assigned to it. We conclude that the detention imposed by the Act falls on the regulatory side of the dichotomy. The legislative history of the Bail Reform Act clearly indicates that Congress did not formulate the pretrial detention provisions as punishment for dangerous individuals. Congress instead perceived pretrial detention as a potential solution to pressing societal problems. There is no doubt that preventing danger to the community is a legitimate regulatory goal. Moreover, the conditions of confinement envisioned by the Act appear to reflect the regulatory purposes relied upon by the government. The statute at issue here requires that detainees be housed in a facility separate to the extent practicable from persons awaiting or serving sentences or being held in custody pending appeal. We conclude, therefore, that the pretrial detention contemplated by the Bail Reform Act is regulatory in nature and does not constitute punishment before trial in violation of the Due Process Clause. We have repeatedly held that the government's regulatory interest in community safety can, in appropriate circumstances, outweigh an individual's liberty interest. For example, in times of war or insurrection, when society's interest is at its peak, the government may detain individuals whom the government believes to be dangerous. Even outside the exigencies of war, we have found that sufficiently compelling governmental interests can justify detention of dangerous persons. Thus, we have found no absolute constitutional barrier to detention of potentially dangerous resident aliens pending deportation proceedings. We have also held that the government may detain mentally unstable individuals who present a danger to the public. We have approved of post-arrest regulatory detention of juveniles when they present a continuing danger to the community. Even competent adults may face substantial liberty restrictions as a result of the operation of our criminal justice system. If the police suspect an individual of a crime, they may arrest and hold him until a neutral magistrate determines whether probable cause exists. The government's interest in preventing crime by arrestees is both legitimate and compelling. The government must first of all demonstrate probable cause to believe that the charged crime has been committed by the arrestee, but that is not enough. In a full-blown adversary hearing, the government must convince a neutral decision-maker by clear and convincing evidence that no conditions of release can reasonably assure the safety of the community or any person. On the other side of the scale, of course, is the individual's strong interest in liberty. We do not minimize the importance and fundamental nature of this right, but, as our cases hold, this right may, in circumstances where the government's interest is sufficiently weighty, be subordinated to the greater needs of society. When the government proves by clear and convincing evidence that an arrestee presents an identified and articulable threat to an individual or the community, we believe that, consistent with the Due Process Clause, a court may disable the arrestee from executing that threat. Under the Bail Reform Act, the procedures by which a judicial officer evaluates the likelihood of future dangerousness are specifically designed to further the accuracy of that determination. Detainees have a right to counsel at the detention hearing. They may testify in their own behalf, present information by proffer or otherwise, and cross-examine witnesses who appear at the hearing. The government must provide its case by clear and convincing evidence. Finally, the judicial officer must include written findings of fact and a written statement of reasons for a decision to detain. The Act's review provisions provide for immediate appellate review of the detention decision. We think these extensive safeguards suffice to repel a facial challenge. Given the legitimate and compelling regulatory purpose of the Act and the procedural protections it offers, we conclude that the Act is not facially invalid under the Due Process Clause of the Fifth Amendment. B. Respondents also contend that the Bail Reform Act violates the excessive bail clause of the Eighth Amendment. We think that the Act survives a challenge founded upon the Eighth Amendment. The Eighth Amendment addresses pretrial release by providing merely that excessive bail shall not be required. This clause, of course, says nothing about whether bail shall be available at all. Respondents nevertheless contend that this clause grants them a right to bail calculated solely upon considerations of flight. They rely on Stack v. Boyle from 1951, in which the court stated that bail set at a figure higher than an amount reasonably calculated to ensure the defendant's presence at trial is excessive under the Eighth Amendment. Respondents concede that the right to bail they have discovered in the Eighth Amendment is not absolute. A court may, for example, refuse bail in capital cases. While we agree that the primary function of bail is to safeguard the court's role in adjudicating the guilt or innocence of defendants, we reject the proposition that the Eighth Amendment categorically prohibits the government from pursuing other admittedly compelling interests through regulation of pretrial release. The above-quoted dictum in Stack v. Boyle is far too slender a reed on which to rest this argument. The court in Stack had no occasion to consider whether the excessive bail clause requires courts to admit all defendants to bail, because the statute before the court in that case, in fact, allowed the defendant to be bailed. 3. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. We hold that the provisions for pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The Act authorizes the detention prior to trial of arrestees charged with serious felonies who are found after an adversary hearing to pose a threat to the safety of individuals or to the community which no condition of release can dispel. The numerous procedural safeguards detailed above must attend this adversary hearing. We are unwilling to say that this congressional determination, based as it is upon that primary concern of every government, a concern for the safety and indeed the lives of its citizens, on its face violates either the Due Process Clause of the Fifth Amendment or the excessive bail clause of the Eighth Amendment.